Thank you, Mr. Speaker. Honourable Senators, I rise before you to lend my support to Bill S-209, an act to amend the Women and Gender Equality Act that Senator McCallum is sponsoring. I will explain how it makes good sense to support this bill when understanding the close link between culture and gender for Indigenous women. This bill is necessary for Canada in seeking robust and effective policy, and most importantly, a necessary bill if we as Canadians are serious about reconciliation. And indeed, it's a necessary bill to protect Indigenous women from the colonial harms they have historically been subjected to. Bill S-209 would make an analysis of culture and gender, which is inseparable for Indigenous women, a statutory requirement, and so ensuring future governments not neglect this important consideration in the studying, debating, and passing of legislation. Gender-based analysis, or GBA, is a tool that allows policymakers to align government actions with the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act. As you know, the Government of Canada has committed to supporting the full implementation of gender-based analysis across federal departments and agencies. Currently, gender-based analysis is undertaken through the discretion and goodwill of government, which leaves future governments an opportunity to dismiss it if they so choose. Of course, departments developing bills are likely to think about their impact on different populations and would likely consider all risks. However, any GBA practices within government for reviewing proposed bills are seemingly at the discretion of the government of the day. We have seen how gender-based analysis shapes how the government identifies and defines problems in its policy responses. In their 2015 report, entitled Implementing Gender-Based Analysis, the Office of the Auditor General evaluated the progress on the work done by the status of women and found a number of areas where improvements were required. Yet the office remained silent on the question of cultural relevancy, which of course leaves a significant gap for Indigenous women. The status of women did clarify that gender-based analysis should also include consideration of diversity factors among groups of women and men, such as age, education, language, geography, culture, and income. Considerations can also include race, ethnicity, religion, and mental or physical disability. This is called GBA+. The further accounting for the relevancy of culture in recognizing the unique realities of Indigenous women in Bill S-209 is an important step towards implementing a culturally relevant gender-based analysis. The Native Women's Association of Canada has been a leader in advocating and implementing a culturally relevant gender-based analysis since 2007. This recognizes culturally relevant factors when implementing their analysis. For example, in the health sector, where I've done much of my work, health research and clinical trials have historically only been conducted on Caucasian males, thereby creating a gap at best or a failure at worst to meet women's needs health. This placed women at great risk because the findings derived from male-oriented clinical trials were considered the gold standard and applied to all women, thereby rendering false and at times dangerous results. For example, when dealing with heart health, the unique considerations of women's heart comorbidities is exacerbated for Indigenous women because of their additional health considerations due to the ill effects of colonialism, such as the stresses and depression from loss of identity through the Indian Act, and the effects of violence perpetrated against generations of residential school survivors. However, using the tools that Bill S-209 provides would remove or greatly reduce the gaps to obtain a more reality-based understanding of Indigenous women's lives, and their health. The Native Women's Association of Canada has provided clear direction on Indigenous roles of women in traditional society that contrasts sharply with Canada's tradition of European concepts, as this has made for a very different and difficult history for Indigenous women in Canada. In fact, when Europeans arrived in Canada, the common law view of women was that they were chattel, that is, property that was dependent first on their fathers and then their husbands. The historical and subordinate status of women in European societies is in stark contrast to that of Indigenous women, who commanded the highest respect in their communities as givers of life and were keepers of the traditions, practices, and customs of their nations. They were revered for their capacity to not only create life, but by extension, the creation of new relationships with the Creator. Women made integral decisions about family, property rights, and education. An Indigenous woman had considerable political power among her people. However, today, patriarchal and masculine assumptions continue to influence our laws and policies. For instance, as noted, a male-centric vision had a long-lasting negative effect on the health of Indigenous women. Colonial laws and policies developed in part by targeting the power of Indigenous women as anchors of the family. Feminism and the Western legal traditions have made some gains in balancing out the injustices, but these conceptions do not entirely reflect Indigenous perspectives. For example, balance in Indigenous society cannot be equated with equality. Rather, balance is understood as respecting the laws and relationships that Indigenous women have as part of Indigenous laws and the ecological order of the universe. So the question is, how can a bill such as 209 assist in creating a more balanced and fair society for all women? Refined legislative tools could, for example, apply a culturally relevant gender-based analysis that takes into account the unique needs of Indigenous women when reviewing things such as environmental legislation that may typically produce camps of male workers for resource extraction in rural and remote areas. Senator McCallum shared these thoughts very eloquently in her speech. A culturally relevant gender-based analysis would assess these risks at the legislative drafting and amendment stage and highlight the need to take into account the potential for violence against Indigenous women in these remote areas. I have previously spoken in this place on the matters of forced and coerced sterilization of Indigenous women, and it remains a deep concern of mine. Presently, my office is working on a map of Canada which will highlight the population of Indigenous women who have been forcibly or coerced into sterilization, with an overlay of the location of Indian hospitals and tuberculosis sanatoriums to see the correlation between the two. Further maps will highlight and overlay the placement of residential schools, prisons, trafficking corridors, mental health centers, and resource camps to better understand any correlations that may exist in relation to the acts of forced sterilization. Maps could also be created and similar overlays used for approximately 5,000 murdered and missing Indigenous women and girls. These intersections are a few types of examples that a culturally relevant, gender-based analysis will help guide us in this most critical step in putting corrective and mitigating policy strategies in place for Indigenous women. Once these maps are completed, we hope to undertake similar work with other sectors that were noted during the short study undertaken in the topic in the Senate Standing Committee on Human Rights. For instance, the study noted how African Nova Scotia women were subjected to unwanted hysterectomies, as were intersex people, people with disabilities, and other vulnerable people in Canadian society. Bill S-209 moves us in the direction of considering the important role culture and gender plays in policymaking and in how some Canadians are treated, often unequally. In a multicultural society like Canada, a culturally relevant analysis can, no doubt, include a number of intersections. In our commitment to reconciliation, we take a first step towards recognizing other cultural realities and the biases that make up the current practices of law and policy making. Bill S-209 is a critical and positive step forward in protecting the specific realities of Indigenous women. The government has committed to reconciliation, which requires a distinctions-based approach to ensure that the unique rights, interests, and circumstances of First Nations, Métis, and Inuit are acknowledged, affirmed, and implemented. Bill S-209 does just that. Sending Bill S-209 to committee and for eventual passage is an important piece of legislature for Canada and today, indeed, for the future of all Canadians. Thank you. Merci. Miigwech.